My grandfather always believed that clear property boundaries prevented future problems. When he passed away, he left me his 950-acre lakeside ranch overlooking Coeur d'Alene Lake, along with every deed, survey, and recorded property map. I promised to protect the land exactly as he had. For decades, our family welcomed neighbors who asked permission to fish, hike, or enjoy the shoreline. Most people respected the property and always checked with us first. That mutual respect kept the community peaceful for years. Everything changed after a new HOA community was built next to the ranch. New residents began treating my private shoreline like a public park. They crossed fences, parked on ranch roads, and ignored the existing boundary markers. Instead of arguing with anyone, I contacted a licensed surveying company. I wanted every property corner verified before making any changes. Accurate records would speak louder than emotions. After several days of measurements, the survey matched my grandfather's original property records almost perfectly. Every boundary marker remained exactly where county records said it should be. The results gave me complete confidence. Based on the updated survey, I ordered professionally made private property. No trespassing signs or the legal property entrances. The signs were respectful, highly visible, and placed entirely inside my recorded boundary lines. My goal was simply to prevent future misunderstandings. Only 2 days later, several HOA residents gathered near one of the new signs. They insisted the community had always used that trail to reach the lake. I calmly explained that the trail crossed private property. Karen Foster, the HOA president, arrived carrying neighborhood maps and demanded that I remove every warning sign immediately. She argued the signs interfere with what she called community access. I politely asked if she had any recorded easement supporting that claim. Karen couldn't produce any recorded easement, but she insisted the signs had to come down anyway. Before leaving, she warned that she would contact law enforcement. I simply wished her a good afternoon and returned to work. The next morning, 2 sheriff's deputies arrived after receiving a complaint that I was trespassing on HOA property. I welcomed them onto the porch, offered them coffee, and invited them to review the official property records. They agreed to examine the documents before making any conclusions. After reviewing my deeds and survey maps, the deputies noticed that every document consistently described the same property boundaries. They explained that property ownership questions are determined through official records, not assumptions. Everyone remained calm as the discussion continued. One deputy suggested verifying everything directly through the county land records office before taking any further action. Karen agreed, convinced the records would support the HOA's position. I welcomed the opportunity for an independent review. Later that afternoon, my attorney joined me at the county clerk's office. Together we requested every recorded deed, survey, easement, and subdivision filing affecting the ranch and neighboring HOA. We wanted the complete history, not just selected pages. The county records confirmed exactly what my grandfather had always documented. No recorded public easement crossed my ranch to reach the lake. Every warning sign had been placed inside my own property line. Armed with certified copies of the records, my attorney sent a formal letter asking the HOA to stop claiming access rights that weren't supported by recorded documents. We also invited the board to discuss lawful solutions if they believed additional access was needed. The next move would be theirs. The HOA rejected our letter and insisted that decades of neighborhood use had created permanent access rights across my ranch. My attorney reminded them that long-term use alone doesn't create legal ownership. We invited them to provide any recorded easement supporting their claim. Instead of providing documentation, the HOA filed a lawsuit requesting that the court order me to remove the warning signs. They argued the signs interfere with residents' access to the lake. We prepared our response using certified county records. The judge scheduled an early hearing and required both sides to exchange every deed, survey, easement, and subdivision record before court. Boxes of documents quickly filled both legal offices. Every page mattered. To eliminate every question, the court appointed an independent surveying company. Their job was simple: measure the property exactly as recorded in county records. Neither side could influence the results. After several days of measurements, the independent survey matched my original survey almost perfectly. The trail, gate, and warning signs all stood completely inside my recorded property. The evidence became difficult to dispute. The courtroom filled with homeowners, reporters, attorneys, and county officials. Many residents believed the HOA already owned the shoreline access. They were about to see the original property records for the first time. My attorney presented the original ranch deed, tax records, subdivision plats, and certified county surveys. Every document described the same property boundary. The judge carefully examined each exhibit before moving forward. The HOA argued that residents had used the trail for years without objection. My attorney explained that long-standing use does not automatically create legal access where no recorded easement exists. The courtroom remained silent. The court-appointed surveyor testified under oath, confirming that every warning sign stood well within my property's legal boundaries. Modern GPS measurements matched the original county survey almost exactly. The testimony strengthened our case. During testimony, county officials confirmed they had found no recorded public easement crossing my ranch. The land records had remained unchanged for decades. Several homeowners looked genuinely surprised. The judge asked whether the parties had attempted mediation before trial. My attorney explained that we had repeatedly offered to discuss alternative access routes if supported by lawful agreements. The HOA had declined every invitation. Following the testimony, the judge recessed to review the evidence. Outside the courthouse, reporters interviewed both sides while residents debated what they had just heard. Public opinion began to shift. When court resumed, the judge ruled that the HOA had not presented evidence establishing a legal right.